It's profoundly disappointing that, having grown up in the era of post-World War II idealism, that I'd be here in the 21st century having to talk about occupation by one country of another. I mean, this is something one would have thought we'd have figured out already. I should also emphasize, of course, is that despite claims to the contrary, the U.S. invasion of Iraq was not an act of self-defense by any legal definition. Indeed, it was not even a preemptive war even if you, no matter how far you stretch it. If anything, it's what's known as a preventative war. This idea that, well, this country, is not an imminent threat. They're not about to attack us or anything, but they might, in this case, someday develop weapons. They might pass on to somebody that might someday be used against us. Now, think for a moment if every country in the world could justify war on those grounds. I mean, you'd have countries invading each other all over the place. There'd be a total breakdown of the international order. The fact is that we were, of course, in no danger from Iraq. This was a war of aggression by any definition. But virtually every nation that's engaged in active aggression, at least in modern times, has done so on the grounds of self-defense. Adolf Hitler justified the invasion of Czechoslovakia because he alleged it was a dagger at our loins. And 30 years later, the Soviet Union invaded Czechoslovakia on the same ground, somehow that it represented a threat as a proxy for Western imperialism. The same kind of ludicrous claim the Soviets used for this invasion of Hungary a dozen years later. The French and British and Israelis invaded Egypt in 1956, arguing that Nasser was somehow another Hitler, claiming that was self-defense. And the Reagan administration went as far as claiming the tiny Caribbean island of Grenada was somehow a threat to national security. And here, we were told that Iraq, which was just a fraction, just a shell of its once formidable military prowess, and when it was, we were supporting that government, somehow was a threat to our national security, when even its neighbors, traditionally hostile to it, did not feel particularly threatened. But of course, it was not just the Bush administration. Remember that the Democrats apparently agreed that Iraq was a threat. They agreed with this doctrine of preventative war. Both the House and Senate Democratic leadership supported the invasion, including a majority of Democratic senators. In fact, the year following the invasion, the Democratic Party gave their presidential and vice presidential nominations to two senators who strongly and falsely claimed Iraq still had weapons of mass destruction, was a serious threat to our national security, and supported this dangerous and illegal doctrine of preventative war. Your Senator, Maria Cantwell, in justifying her vote to grant President Bush unprecedented war powers to invade a country on the far side of the planet whose offensive military capability had already been systematically dismantled, claimed that Iraq constituted, in her words, quote, a unique threat that will grow increasingly more dangerous. If Congress did not authorize the invasion of that oil-rich country, she claimed, this danger, quote, will grow increasingly more dangerous as Saddam Hussein increases his chemical, biological, and nuclear weapons stockpile. The reality, of course, was Saddam never had a nuclear weapons stockpile. It's highly questionable as to whether he ever had a biological weapons stockpile. And it was well known at the time that 95% of his chemical weapons stockpile had been accounted for and destroyed. And if any remained, and we now know that none of it did, the shelf life of the chemical agents would have long since expired. Furthermore, there is absolutely no credible evidence that Iraq had subsequently manufactured or even had the wherewithal to manufacture any new weapons of mass destruction, and the strict sanctions placed on that country, which had made it impossible for them to import any of the necessary raw materials or technology from advanced industrialized countries that made possible their development of such weapons in the 1980s. Now, Ms. Cantwell and these other folks should have known that. I mean, I knew it. I wrote about this. Some of you were maybe at my talk at Kane Hall. You may recall just before the war where I spelled out that all the evidence suggested that Iraq at least qualitatively disarmed. Now, and if an associate professor at a Jesuit college on the West Coast could have figured that out, why couldn't Maria Cantwell or those other people in Washington who had far more access to information than I did, figure that out as well? You could have found articles about this. I mean, it wasn't just me, of course. You would look at scholarly journals like Arms Control Today, Bulletin of Atomic Scientist, Middle East Policy, and as well as more popular magazines like The Nation. I understand Cantwell is up for re-election next year. It'll be interesting if the people of Washington believe that such dishonesty, fear-mongering, and contempt for international law should be rewarded by an additional 6 years in office. But turning to the question of occupation itself, there are a number of countries in the world which could arguably be considered occupied. Some would consider my home in Santa Cruz, California, part of occupied northern Mexico. Native Americans would consider most of the United States occupied territory, prompting the bumper sticker that's often seen on Indian reservations, U.S. out of North America. In a recent visit to Greece, I noticed that on the weather maps they still refer to Istanbul as Constantinople. Many Irish nationalists still see the 6 counties of the north as under British occupation. And many Palestinians see not just the West Bank and Gaza as occupied, but all of Palestine as occupied territory. Chechens want freedom from Russia. Achenese want freedom from Indonesia. And who among us has not been moved by the courageous, nonviolent struggle of the people of Tibet from Chinese rule? Yet there are only a handful of cases in recent decades where a country has attempted to effectively expand its territory by military force, territories that could reasonably be considered non-self-governing territories under foreign military occupation in violation of UN Security Council resolutions denouncing their occupation and calling for the withdrawal of foreign forces. Some occupations, I should mention, have been reversed. Somalia's 1975 invasion of the Ogaden region of Ethiopia, quietly supported by the United States, was soon reversed. Iraq's 1980 invasion of Iran, also quietly supported by the United States, was reversed following a bloody 8-year war. Iraq's invasion and annexation of Kuwait was reversed 6 months later through the U.S.-led Gulf War. 30 years ago this week, Indonesia invaded East Timor, leading to the deaths of 200,000 people, nearly a third of the island's population, before Indonesians finally withdrew in a final orgy of violence 5 years ago. And over the objections of the Clinton administration, the Israeli government of Ehud Barak finally came into compliance with UN Security Council Resolution 425 and 9 subsequent resolutions by finally withdrawing its occupation forces from Lebanon in May of 2000 after a 22-year occupation. Now, despite the illegality of the U.S. invasion of Iraq and the enormous violence and suffering that's followed, Iraq is no longer under formal occupation. U.S. domination of the country continues, however, and I'll touch upon that later. Regarding the officially recognized occupations, which number 4 at this time, I wish to start with the most obscure of them, involving Azerbaijan, Armenia, and Nagorno-Karabakh. Not only are very few people familiar with it, but it's somewhat confusing since, as with the case of Israel, the country that is legally the aggressor consists of survivors of genocide, and the aggressor country is more democratic than its rival. Briefly, when the Soviet Union was falling apart in 1991, the neighboring republics of Azerbaijan and Armenia became independent, and the enclave of Nagorno-Karabakh, primarily populated by ethnic Armenians but located within Azerbaijan, declared itself independent as well. In the war that followed, there was ethnic cleansing on both sides, and Armenian forces seized parts of Azerbaijan, including Nagorno-Karabakh, rejecting calls by the UN Security Council to withdraw. A ceasefire has been in effect since 1994. And Nagorno-Karabakh functions as a de facto independent state, closely tied to the Republic of Armenia, uses Armenian currency, and sharing political leadership. Successive Armenian governments have resisted internal pressure to formally unite the two, fearing reprisals from Azerbaijan and from the international community that still considers Nagorno-Karabakh a part of Azerbaijan. Even if one accepts the legitimacy of Nagorno-Karabakh's claim of independence and a desire to unite with Armenia, Armenian forces remain in occupation of a strip of land which is indisputably part of Azerbaijan, connecting the two, known as the Lachin Corridor. The second case I wish to mention is the island nation of Cyprus, where roughly 80% of the population is ethnic Greek. The remaining 20% are ethnic Turk. In August of 1974, in reaction to a coup by right-wing Greek Cypriots, which sought to unite with Greece and feeling that the island's Turkish minority was threatened, Turkish troops invaded. Within days, they seized the northern 40% of the country and engaged in ethnic cleansing against the Greek-speaking population. The United Nations Security Council passed a series of resolutions, 10 resolutions in fact, calling on Turkey to withdraw its forces, but the Turkish government refused to abide by these resolutions, and the United States blocked the United Nations from enforcing it. The Carter administration convinced Congress to end its arms embargo on Turkey that it had imposed at the time of the invasion, saying we need to be able to give these arms to Turkey because it will advance the peace process and get them to compromise. But here we are, more than a quarter century later, and the island is still under, 40% of the island is still under Turkish control. In 1983, the Turkish-occupied section declared itself an independent state, seceding from the Republic of Cyprus. No country has recognized that, besides Turkey. The UN Security Council passed two more resolutions, 541 and 550, demanding that the declaration of independent Turkish Cypriot state be rescinded, and of course Turkey and the new Turkish Cypriot state, knowing that the U.S. would block any enforcement of the resolution, ignored it. Beginning in the late 1990s, the UN Security Council resolution passed a series of resolutions aimed only at reducing the number of Turkish occupation forces as a means of creating a more favorable climate for peace talks. These resolutions were also ignored. And what finally moved things forward was that the growing prosperity of the unoccupied 60% of the island relative to the Turkish-occupied north, the country's imminent inclusion in the European Union, and Turkey's desire to eventually join the EU as well, did finally lead to serious peace talks. And the U.S.-backed United Nations plan was put forward that would have reunited the island, but under a loose federation that would have largely legitimized the forced partition of the island, though the ethnic Greek sector would have been able to reclaim a small portion of the land currently under Turkish control. The failure to allow the ethnic Greeks to reclaim their confiscated property in the Turkish-occupied sector, however, led to the referendum on the reunification plan in April of 2004, and so it looks unlikely that a new peace effort will go forward anytime soon. Well, in these two cases, the vast majority of those under occupation are of the same ethnicity as their occupiers, and even more as liberators. So whatever the illegality of the initial invasion and the ethnic cleansings that followed, those in the occupied territories largely support the status quo. The remaining two cases I want to talk about follow a more classical case of foreign military occupation that is against the will of the inhabitants, and not surprisingly is subject to ongoing serious human rights abuses. I'll begin with the Western Sahara. In November of 1975, just prior to a scheduled withdrawal of Spanish colonial rule, where there was going to be a referendum where the people of the territory would decide on independence or incorporation, possibly with Morocco or with Mauritania, the country was invaded by its large Moroccan neighbor. Most of the population fled into exile into neighboring Algeria, where they remain in refugee camps administered by the Sahrawi Arab Democratic Republic, the Western Sahara government in exile, which is recognized by more than 75 nations as the legitimate government of Western Sahara. In fact, it's a full member of the African Union. The International Court of Justice ruled the previous month that despite Morocco's claims of fealty to the Sultan by nomadic tribesmen in that area in previous centuries, the right of self-determination remained paramount. And there is little question with those familiar with the country, including a United Nations delegation that was sent to investigate the situation earlier that year, that the overwhelming majority of the population desired independence under the leadership of the nationalist Polisario Front. The United Nations passed resolutions 377, 379, and 380 calling on Morocco to respect the right of the people of Western Sahara for self-determination and for Morocco to withdraw its forces. Morocco has ignored the resolutions, but it, again, was protected from sanctions and other means of enforcement by threats of a veto by the United States, as well as France, both close allies of the Moroccan monarchy. Meanwhile, Morocco has sent thousands of settlers into the territory in violation of Article 48 of the Fourth Geneva Convention, which prohibits occupying powers from transferring parts of their civilian population onto territory seized by military force. Fighting between Moroccan occupation forces and guerrillas of the Polisario Front led the Polisario Front to nearly liberate the entire territory by 1982, but massive new aid from the Reagan administration, including counterinsurgency training by U.S. Special Forces, led to a reverse of the war and the construction of a sand berm, nicknamed the Wall, which has kept most of the Sahrawi population out of their own country and has led to Moroccan control of a good 3/4 or more of the territory, leaving only the barren desert parts on the eastern edge that essentially has become a no man's land. But in 1991, fighting stopped when a ceasefire was proclaimed, sponsored by the United Nations. And it was supposed to have been the first stage of a UN-managed process that would have led to a referendum for the people living in Western Sahara as of 1975 and their descendants, including repatriated refugees that had been living in Algeria since the Moroccan invasion. However, Moroccans refused to fully cooperate with UN officials in the voter identification process and continued to suppress pro-independence activities in violation of a series of nearly a dozen UN Security Council resolutions that would have paved the way for the referendum. Again, France and the United States blocked the Security Council from implementing any kind of enforcement mechanisms. The diplomatic stalemate appeared to be broken through efforts of a UN Special Envoy and former U.S. Secretary of State James Baker in September 1997 with an agreement between Morocco and the Polisario Front signed in Houston, where the parties appeared to have agreed to an identification process and a code of conduct for the long-awaited plebiscite, but Morocco again refused to cooperate with UN efforts at registering and identifying voters and other activities of UN peacekeeping forces, again in defiance of a new series of UN Security Council resolutions. In 2000, the Clinton administration successfully convinced Baker and Secretary General Kofi Annan to give up efforts to proceed with the referendum as originally agreed upon, and to instead accept Moroccan demands that Moroccan settlers be allowed to vote on the fate of the territory, along with the indigenous Sahrawis. The proposal was incorporated in the first Baker Plan of 2001, which held the plebiscite under Moroccan rule after a 4 or 5 year period of very limited autonomy and no guarantee that independence would even be one of the options on the ballot. The Baker Plan received the enthusiastic support of the new Bush administration, which had come in office in part through Baker's role as lead counsel for the Bush campaign regarding the disputed Florida election that November, leading some analysts to know that it was only appropriate that he would put forth a plan that would effectively give legitimacy to a rigged election. Most of the international community roundly rejected the proposal, however, since it would have effectively abrogated previous UN Security Council resolutions granting the right of self-determination with the option of independence, and would have led to the unprecedented action of the United States placing the fate of a non-self-governing territories in the hands of the occupying colonial power. As a result, Baker then proposed a second plan where, as with the earlier proposals, both Sahrawis and Moroccan settlers would be able to vote on the referendum, but the plebiscite would take place only after Western Sahara experienced far more significant autonomy for the 4 or 5 years prior to the vote. Independence would be an option on the ballot, and the United Nations would oversee the vote and guarantee that both advocates of integration and independence would have the freedom to campaign openly. And the UN Security Council approved this Second Baker Plan in the summer of 2003 in Resolution 1534. Under considerable pressure, Algeria and eventually the Polisario agreed to accept the new plan. But Morocco, unwilling to even allow the territory to enjoy a brief period of autonomy and risk the possibility that they might lose the plebiscite, rejected it. And once again, the United States and France blocked the UN from enforcing its mandate by pressuring Morocco to comply with its international legal obligations. And what has been widely interpreted as rewarding Morocco for its intransigence, the Bush administration subsequently designated Morocco as a major non-NATO ally in June of 2004, a coveted status currently granted only to 15 nations, such as Japan, Israel, and Australia. The following month, the Senate ratified a free trade agreement with Morocco by an 85-13 margin, making the kingdom one of only a half dozen countries outside the Western Hemisphere to enjoy such a close economic relationship with the United States, though in a potentially significant precedent, Congress insisted that it not include products from the Western Sahara. U.S. aid to Morocco has gone up fivefold since the Bush administration came to office, ostensibly as a reward for the kingdom undertaking a series of neoliberal economic reforms and to assist the Moroccan government in combating terrorism. While there has been some political liberalization within Morocco in recent years under the young King Mohammed VI, who succeeded the throne following the death of his father in 1999, gross and systematic human rights violations in the occupied Western Sahara continued unabated, with public expression of national sentiments and organized protest against the occupation and human rights abuses routinely met with severe repression. Now, unlike Morocco's invasion of Western Sahara and Turkey's invasion of Cyprus and Armenia's invasion of Azerbaijan, when Israel seized the Jordanian-controlled West Bank and Egyptian-controlled Gaza Strip, the Golan region of Syria, and the Sinai Peninsula of Egypt in June of 1967, the United Nations did not call for an immediate unconditional withdrawal. While underscoring the principle enshrined in the UN Charter that no nation can expand its territory by force, the UN Security Council in 242 and 338 resolutions made Israel's withdrawal from the occupied territories conditional on security guarantees from Israel's Arab neighbors that had been threatening to destroy the Jewish state since its establishment in 1948, which emerged out of the partition plan of the United Nations General Assembly the previous year. The Arab states and the Palestine Liberation Organization initially rejected these Security Council resolutions, so there are some indications that some of them were moderating this rejectionist stance as far back as the mid-1970s. By the early 1990s, it appeared that the PLO and virtually every Arab state was ready to accept the principle of land for peace. Even without an Israeli withdrawal from the West Bank, Gaza Strip, and Golan Heights, Egypt signed a formal peace treaty in 1978, and Jordan signed a formal peace treaty in 1994. In March 2002, at the Beirut summit of the League of Arab States, a resolution endorsing a peace plan by Saudi Crown Prince Abdullah that essentially reiterated 242 and 338 with an additional promise of full normal diplomatic relations was adopted unanimously, but it was rejected by Israel. Now, some supporters of the Israeli occupation claim that the resolution spoke of territories rather than the territories, implying that there's no obligation for a full Israeli withdrawal. But by this interpretation, simply returning the Sinai and little bits and pieces of the West Bank would thereby fulfill Israel's obligations. However, the resolution's text in French, which is the other official language of the UN, does use the definite article. And furthermore, the authors of the original resolution, 242, who are the American and British ambassadors to the UN, explicitly stated that they were only thinking in terms of very minor and reciprocal adjustments of the jagged border that was based upon the ceasefire lines codified in the 1949 Armistice Agreement. The security guarantees called for in the resolutions were generally interpreted to mean promises of non-aggression by neighboring states, presumably enforced by some combination of arms control, demilitarized zones, early warning systems, and international peacekeeping forces. The United States and Israel, however, have dramatically expanded this interpretation, now insisting that the resolution essentially requires the physical safety of every Israeli citizen be somehow guaranteed. In effect, the Israeli and American governments argue that Israel is in no obligation to withdraw from the occupied territories unless there's a total halt of attacks by suicide bombers or other terrorists. And since most of these come from underground terrorist cells that are beyond the effective control of any government, much less a disempowered Palestinian Authority under siege by Israeli forces, and these Islamic extremists, of course, remember, explicitly want to sabotage the peace process through violence. This interpretation by the U.S. government effectively means that Israelis need not be under any obligation to withdraw. There are other Security Council resolutions where Israel's ongoing violations are even clearer. These include resolutions 446, 452, and 465 and 471, which require Israel to cease its colonization of the occupied territories through the establishment of Jewish settlements, which again are illegal under the Fourth Geneva Convention. I mentioned those in reference to Morocco's settlement policy as well. Yet both the Clinton administration and the current Bush administration insists that the fate of the settlements are up for negotiations between the two parties. Not only does this ignore the gross asymmetry in power between the Palestinians and their Israeli occupiers, but it's already been decided. These settlements are illegal, and Israel must withdraw from them, period. Significantly, Article 7 of UN Security Council Resolution 465 forbids all member states from facilitating Israel's colonization drive. And given that the United States has largely been funding the construction of the so-called bypass roads and other infrastructure reinforcing Israeli settlements in the occupied territories, one can make the case that the United States itself is in violation of this resolution. Back in 1992, I was chair of the board of Washington State St. Freeze and involved in politics here. And I remember Patty Murray was running for Senate for the first time. Maria Cantwell was running for the House for the first time in the 1st District. And they along with presidential candidates Bill Clinton, Tom Harkin, and others, attacked incumbent President George Bush from the right for withholding a $10 billion loan guarantee until Israel would put a freeze on building additional settlements. In other words, President Bush wasn't saying that Israel has to live up to its obligations and withdraw from these settlements. All he was saying was, you know, we'll just withhold this. You just shouldn't build any more. But Cantwell and Murray and Harkin and Clinton, those folks, you know, said this is wrong. This should be unconditional. They claimed this is housing. This is for housing for these Jewish refugees from the former Soviet Union. Well, in fact, if you read eventually Bush capitulated under this pressure and essentially signed it away with no conditions. But it's interesting, if you actually read the agreement, there's not a word about housing for refugees. Indeed, I was in Beersheba, which is an Israeli city down in the Negev where most of the new immigrants come. There are 5,000 empty housing units in Beersheba alone. There's a housing surplus in Israel. This is just a ruse. The only houses these contributed to building were illegal settlements. And there are twice as many of these settlements today as there were in 1992. And they are the main reason that Israel has not been willing to withdraw from the West Bank to help create a viable Palestinian state. Why Barak's so-called generous offer, in fact, was not a particularly generous offer because he insisted on incorporating so many settlements. The West Bank was divided up even worse than a badly gerrymandered congressional district. I mean, it was like the Bantustans of South Africa. It would have been completely inviable, non-contiguous cantons, and even a Palestinian leader, you know, more smarter and more ethical than Arafat, could not have accepted that. No Palestinian could have accepted this kind of offer. Another series of UN Security Council resolutions deal with the status of Jerusalem. Israel is currently in violation of UN Security Council resolutions 262, 267, 476, and 478, among others, which call upon Israel to rescind its annexation of Arab East Jerusalem and surrounding areas seized in the early days of the '67 war, and to cease all activities which attempt to change the city's status. Article 5 of Resolution 478 calls upon all member states of the UN to accept this decision. However, through a series of executive orders and congressional resolutions, the United States has effectively recognized Israeli sovereignty over all of Greater East Jerusalem. And again, this has been bipartisan with overwhelming Democratic as well as Republican support. Other resolutions currently being violated by Israel include UN Security Council Resolution 487, which calls upon Israel to place its nuclear facilities under the safeguard of the UN's International Atomic Energy Agency. UN Security Council Resolution 497, which demands that Israel rescind its decision to impose its domestic laws in the occupied Syrian Golan region. UN Security Council Resolution 573, which calls on Israel to pay compensation for human and material losses from its 1985 attack on Tunisia. And resolutions 1402, 1403, 1405, which require Israel to withdraw from occupied Palestinian cities in the West Bank. There are also well over a dozen resolutions currently being violated which insist that Israel abide by the Fourth Geneva Convention regarding the occupied territories, including ceasing its deportations and assassinations of Palestinians, its demolitions of Palestinian homes and other forms of collective punishment, as well as controlling violence by settlers against the Palestinian population. And this does not include the more than 40 UN Security Council resolutions that have been vetoed by the United States. Indeed, the United States has used its veto power to block enforcement of the Fourth Geneva Convention regarding Israel since starting in the early 1970s, more times than all the other members of the Security Council have used their veto power on all other issues combined. Now, the Israeli government and many of its supporters in Congress claim that the Fourth Geneva Convention does not apply, since the West Bank and Gaza Strip prior to 1967 was in question. Yet, even if Jordan's sovereignty over the West Bank between 1949 and 67 was legally questionable, it was certainly never part of Israel. And it does not take away from the fact that it is legally recognized as under belligerent occupation, which has been formally acknowledged by the UN Security Council and a near unanimous ruling of the International Court of Justice. Furthermore, it does not explain why the Golan Heights, which is indisputably part of Syria prior to 1967, should be subjected to the colonization, annexation, human rights abuses by the Israelis against the Syrian Druze living under their occupation. Now, the one area that the United States has tried to get out of its obligations is what we saw starting the Clinton administration, where they began referring to the West Bank and Gaza Strip and Golan Heights not as occupied territories, but as disputed territories. This is significant because disputed territories implies both sides have a legitimate claim to the land. Now, the only disputed territories I'm aware of in the region were the Taba Strip, which is a few hundred meters near the southern border of Egypt and Israel. Binding arbitration led by the United States led to a decision in Egypt's favor in that one. You know, there's the Shabah Farm area between Lebanon and Israeli-occupied Syria. But you know, that's those are the only really disputed territories that I'm aware of. The rest are clearly under occupation. The other effort is denial that Israel's even violating international humanitarian law. During Israel's offensive in the spring of 2002, Amnesty International, among other human rights groups, documented quite thoroughly Israel's attacks against the civilian infrastructure, its extrajudicial killings, mass detentions, firing into civilian areas, interference with medical personnel. Indeed, the Amnesty International quite explicitly said it was an offensive against the civilian population as a whole. In response, Tom DeLay, the Republican leader, introduced a resolution saying that Israel, supporting Israel's offensive and saying it was aimed, quote, solely at the terrorist infrastructure, end quote. So the House of Representatives was faced with a choice. Who do you believe? Amnesty International or Tom DeLay? And in the 435-member House of Representatives, with only 21 dissenting votes, the House, Republican and Democrat, decided they believed this right-wing, corrupt, Texas fundamentalist Republican over that of a Nobel Peace Prize winning human rights organization. But again, it didn't start with this, with the post 9/11 period. When asked about enforcement of Security Council resolutions, Madeleine Albright said, "Oh, since the signing of the Oslo Accords, these Security Council resolutions are no longer relevant." Now, even my students in Intro International Relations can tell you that no agreement between two parties takes precedent over a UN Security Council resolution, particularly if one of the two parties, in this case the Palestinians, still insists that they're relevant. I have heard Kofi Annan in person twice say that these resolutions are still relevant. To my knowledge, every single member of the Security Council except the United States insists that they are still relevant. And yet the United States insists that we alone have the power to determine which resolutions still apply and which ones do not. I'd like to take a few minutes to look at a particularly disturbing case, which I think says a lot about the U.S. attitudes towards international law and human rights. And that is, a year ago in July, the International Court of Justice determined that the Israeli government's construction of a separation wall running through the occupied Palestinian West Bank was illegal. They noted that the wall that had been constructed thus far, quote, has involved the confiscation and destruction of Palestinian land and resources, the disruption of the lives of the thousands of protected civilians, and the de facto annexation of large areas of territory. The court went on to call on Israel to cease construction of the wall, to dismantle what had already been built in areas beyond Israel's internationally recognized border, and to compensate Palestinians who've suffered losses. The vote was 14-1. A not unexpected margin, given that it was quite sound legally. The majority included the highly respected conservative British jurist, Rosalind Higgins. The sole dissenter was the American judge, and even his dissent was based largely on a technicality. And the 57-page decision examined in detail the various arguments by the interested parties and was consistent with strictures set up by the UN Charter, a series of UN Security Council resolutions, previous decisions by the World Court, and relevant international treaties. As clear-cut as it was, though, it was denounced by the Bush administration, by Democratic nominee John Kerry, and the vast majority of Congress, of both parties. And what was disturbing about it was a number of things. That for example, John Kerry said, this is not a matter for the International Court of Justice. I do not believe that the International Court of Justice should have been considering this issue, given that they do not have jurisdiction. He went on to say it should be settled by Israeli courts, which implies that Israel has jurisdiction, control over territory that the United Nations Security Council and the international community, World Court, clearly sees as occupied territory. So he's in fact recognizing Israel's legal control over land seized by military force, again direct counter to the United Nations Charter. And Kerry vigorously defended President Bush's decision to oppose the resolution and to convey this opinion to The House of Representatives, by a 361 to 45 majority, voted to deplore the World Court's decision. Senator Gordon Smith in Oregon introduced a resolution that was, along with Patty Murray, that, quote, supports the construction by Israel of a security fence to prevent Palestinian terrorist attacks, condemns the decision of the International Court of Justice on the legality of the security fence, and urges no further action by the United Nations to delay or to prevent the construction of the security fence. Tom Lantos, California Democrat, the ranking Democrat in the House International Relations Committee, called the World Court ruling a perversion of justice. And to give an idea of how seriously Congress takes human rights, he has continually been reappointed to be chairman of the so-called Human Rights Caucus on Capitol Hill. Now it's interesting, the court ruling acknowledges the tragic realities that, quote, Israel has to face numerous indiscriminate and deadly acts of violence against its civilian population, and that Israel, quote, has the right, indeed the duty, to respond in order to protect the lives of its citizens. However, it goes on to say it is nevertheless bound to remain in conformity with applicable international law. In other words, Israel, like any country, has the right to protect its borders, but doesn't have the right to, in the name of security, engage in this land grab, in this case by constructing this combination of fence and walls in this serpentine matter that ends up annexing huge pieces of territory. However, Congress claimed that somehow they were ganging up on Israel. Hillary Rodham Clinton, quote, said, "It makes no sense for the United Nations to vehemently oppose a fence which is a nonviolent response to terrorism rather than opposing terrorism itself." Interestingly enough, the Democrats' position, and Democrat and Republican united position, was more hardline than the Israeli Supreme Court. In fact, the Israeli Chief Justice wrote in a case brought before him that, quote, only a separation fence built on the base of law will grant security to the state and its citizens. Only a separation route based on the path of law will lead to the security so yearned for. But again, and I talk about this in my book, that in many cases the U.S. Congress and the administration has taken positions to the right of the Israeli government itself. They also insisted that the International Court of Justice had some ideological bias against Israel. But if you look at the other two advisory rulings they have had on occupied territory, Morocco and Western Sahara in 1975, South Africa and Namibia in 1970, they also ruled against the occupier. So again, there's nothing unique here. These congressional resolutions also claim that this wall was respecting the human rights of the Palestinians, contradicting, again, Human Rights Watch, Amnesty International, and others, and of course deny that the West Bank is occupied territory. Murray's resolution, for example, used the term disputed territories and the like. And I think, though, why they did this was key, because what was really important about this resolution is that it obliged all signatories of the Fourth Geneva Convention, including, of course, the United States, to do what they could to uphold it. And said they could not facilitate its violations, not just by the government itself, but by other governments. In other words, this had very dangerous precedent in terms of what the United States is doing in Iraq. Now, there's a lot one can say about Israeli violations of international humanitarian law in the occupied territories. But, for example, though Israeli war crimes in Jenin in the spring of 2002 were horrific, they pale in comparison to American war crimes in the siege of Fallujah. The torture and abuse of Palestinian prisoners by the Israelis is indeed terrible, but it pales in comparison to what the United States has been doing in Iraq, Afghanistan, Guantanamo, secret prisons in Eastern Europe, etc. And Israeli violations of fundamental international humanitarian law are widespread and have a terrible human cost. But again, pale in comparison to what the United States has done in the case of Iraq. And even though Iraq is no longer formally occupied territory, the U.S. maintains a quasi-occupation. For example, it maintains extraterritorial rights for Americans, so that no crime, no matter how severe, that an American commits can be prosecuted under Iraqi law. Americans have prominent position in virtually every Iraqi ministry and largely control the budgets. The countries has gone under the transitional administrative laws undertaken by Paul Bremer, a number of radical changes, especially on neoliberal economic lines. Unrestricted repatriation of profits, unrestricted foreign ownership, flat tax, et cetera, has been imposed. And due to the constitutional strictures that we've tried to put in, it's virtually impossible to overturn these. The media, the regulatory committees dealing with media and public various financial regulations, et cetera, are controlled by American appointees, which cannot be removed until at least 2009. In many ways, it remains a neo-colonial situation. And so even with relatively free elections, even with a relatively representative government, they don't really have a lot of power. And for many Iraqis, they're not going to have much credibility because they will be seen, rightly or wrongly, as puppets of the United States. And as a result, resistance and violence are going to continue. Now, but let me just go back, since I'm taking more time than I thought I would. That this is not new. This does not start with the neocons. This does not start with the Bush administration. When Morocco invaded Western Sahara and Indonesia invaded East Timor, and the United Nations voted unanimously to denounce these acts of aggression and call for the withdrawal of foreign forces and to recognize these countries' right to self-determination. Daniel Patrick Moynihan, our ambassador to the United Nations, later a three-term Democratic senator, wrote in his autobiography how he had made the United Nations, in his words, as ineffective as possible in dealing with the resolution, as in enforcing these resolutions. That was a task given to him by the State Department. In his words, I accomplished this task with no inconsiderable success. And we try to justify the invasion of Iraq because United Nations Security Council resolutions must be enforced. Yet I've documented over 100 UN Security Council resolutions currently being violated, the vast majority by allies of the United States, that we have blocked from enforcement because they are allies. Now, some people argue, well, when it deals with Israel, Turkey, Morocco, whatever, these are under Chapter 6 of the UN Charter, dealing with Pacific settlements of dispute, while most of those dealing with Iraq fell under Chapter 7, action with respect to threats to the peace, breaches of peace, acts of aggression. This does not mean that the resolutions under Chapter 6 are merely advisory, however. They are just as mandatory as those under Article 7. The only difference is that those under Chapter 6 do not have the same stringent enforcement options, such as the use of military force. It's also important to note the choice of which resolutions fall into which category has nothing to do with the severity of a given nation's violation of international law or the human impact of the country's transgressions, as much as it does with the violator's relationship with the major powers on the Security Council. For example, resolutions dealing with Indonesia's invasion and massacres in East Timor were placed under Chapter 6, while a resolution addressing an extradition dispute between the United States and Libya was put under Chapter 7. Now, I mean, it's perhaps ironic that the United States, the country more than any other that was responsible for the establishment of the United Nations, for the Fourth Geneva Conventions, for the international humanitarian law, is now the country most responsible for undermining them. More importantly, the politicization of the Security Council by the United States in order to support its invasions and occupations that we've done ourselves and our allies have done, has seriously undermined the authority of the UN and international legal system, thereby threatening the very legitimacy of 20th century concepts of an international system based upon legal principles and replacing it with some kind of 19th century notion of the right of conquest, power politics. This raises the questions as to whether the apparent willingness of the world's sole remaining superpower consistently, the unwillingness of the United States to uphold these principles, particularly in the Middle East, is related to the rise of extremist groups from that region who also violate international legal norms, such as the use of terror against civilians, as a means of challenging the United States and its allies. Because if the United States, with all its enormous financial, military, and diplomatic resources, refuses to play by the rules, why should the weak and powerless? This underscores an important point, that the international legal framework codified in the UN Charter and the Fourth Geneva Conventions was not simply a normative construct by liberal idealists, but a strategic assessment that such a system is necessary to prevent international anarchy and protect the United States and its allies against threats to its national security. And what we see in the policies of politicians like George W. Bush, Patty Murray, Maria Cantwell, John Kerry, Hillary Rodham Clinton, Dick Cheney, Donald Rumsfeld, all these folks, through their support of these occupations, they're rejecting this assessment. A new bipartisan consensus is emerging that argues that security comes not through the universal application of the rule of law, but through unilateral application of superior military force. And needless to say that even putting aside the moral questions, the legal questions, I would argue that this is a real risk to our national security. And this gives hope in many respects, because this traditional division between those of us who've talked about U.S. foreign policy on the grounds of international law and human rights and these kinds of things, and those who've looked at U.S. foreign policy in terms of national security, national interest, we're really one and the same. Because the United States gets in trouble, not because of our values, but when we stray from those values. When the United States stood up for international law against the idea of aggression and occupation in 1956 in the tripartite invasion of Egypt, the United States was celebrated throughout the Arab and Islamic world because we stood up for principle. Well, in reality, and I've actually seen the National Archives, we were afraid if we didn't, these countries would go to the Soviets, but it paralleled with principle at least, that there was, but it did, and it worked. I mean, that we gain enormous amount of respect in that part of the world. Yet, and I've traveled the Middle East for over 3 decades now, and the more we've militarized the Middle East, the more we've undermined these principles, the less secure we become. And there should be a lesson there. And so, yeah, that's why I think there's hope that we can go beyond those of us who look at these issues on largely moral and legal grounds, and build a broad coalition with those who recognize that these, if they don't think they're necessarily important for their own sake, believe they're important for our national security. And people can make a difference. I guess I'd like to close by looking at 2 case studies, Namibia and East Timor, where international solidarity through the sanctions movement against South Africa and divestment campaigns and the work around by church groups and human rights groups around East Timor were able to make the difference. I mean, let's look at East Timor. That was considered the ultimate hopeless cause. I mean, Indonesia was literally 200 times the size and population of East Timor. The guerrilla fighters down to a few hundred with World War II vintage rifles. They had virtually no international support. Even the United Nations had dropped the ball. None of Indonesia's neighbors supported East Timor. Major powers, like especially those most influential with Indonesia, like Australia, Britain, and the United States, were supporting the occupation. And yet the organizing of non-governmental organizations refused to let the issue die, to the point where when Indonesia's economy went down the tank in the East Asian financial collapse in 1998, the British and French and Australians said, hey, we'd like to bail you guys out, but this East Timor thing is making it politically impossible. This half island just isn't worth it to you. And so they allowed the East Timorese to be free. This would not have happened were it not for people like you, who insisted that certain principles, like the right of self-determination, international law, and the right of people to be free from foreign military occupation were important for its own sake. And that's where I have hope. Because as cynical as you may want to be about governments, governments are ultimately accountable for their people. And I believe we keep raising these questions about occupation, about Iraq, about Palestine, about Western Sahara, that we really can turn things around because we've done it before. We do have that power. And we're not alone. There are people in other nations who are raising these same issues and same concerns. And we have certain democratic rights that people under occupation do not have. We have the power to stop the economic and military and diplomatic support that makes these occupations possible. As a result, we have an obligation to work to an end of the occupation, to support for human rights. And I think, as history has shown us, we have the ability as well. And I hope you'll join me in making this possible. Thank you.